All right, now we can get down to business. Again, thank you all for being here. My name is Hamdi Mohammed. I'm the Director of the Office of Immigrant and Refugee Affairs. Today's session is for service providers. We wanted to host this event in person. The last time that we did a training for service providers, it was online. How many of you guys participated in that online training? It was huge, right? It was like 1,000 people participated, and ultimately it ended up shutting down our teams, and then other people were broadcasting it on different sites. And so we thought this would be better for us to host it in person, and we have videographers here that will capture the presentations today, and those videos will go online so that you can distribute that to your colleagues who might not participate in today's training. The Office of Immigrant and Refugee Affairs in this moment is one of our top priorities is making sure that we get accurate information out to community to provide support to our immigrant and refugee serving organizations. And I just want to acknowledge that we are all in unprecedented times. The challenges are real, and I recognize that you all are frontline workers, that you all are grassroots organizations that are directly hearing from community organization, from clients as well as residents in the city of Seattle. And that is a lot of weight to carry, and at times you have to hear other people's trauma, and you might even be someone who is from a mixed immigration status household. And so I recognize that for many of you in this room, that this work is not only work that you do professionally, but that it's also personal. And so I wanted to name that and call it out and recognize it. I want to thank Seattle Library for allowing us to host this convening in this space. We have partnered with the library for many years, and they've been a great partner and have made sure that we have a space that is inclusive, that is accessible to all. And so thank you to the staff who are here from Seattle Library and for the work you do. Please give them a round of applause. This training also was made possible through our continued partnership with the Northwest Immigrants' Rights Project. Malou's here from there, the executive director, and Henry is also here. They have been providing these trainings also, our attorneys on the front line doing this work, and so we thank them so much for their continued work and for consistently showing up. I also want to take this moment to thank my staff from the Office of Immigrant and Refugee Affairs. Oksana Belobrin is here and will be presenting today, but there's a lot of folks who are here who are doing work behind the scenes, and so please give them a round of applause for their continued work. Again, today's session will take a closer look at the impact of Trump-era policies, explore the protections available at the local level, and we'll share best practices for how we, as service providers, you all, can stand with and support our immigrant and refugee communities. I also just wanted to let you all know that we have stood up a rapid response program in our office and are currently in the process of contracting with a number of our local service providers. And we will be doing things like Know Your Rights trainings in partnerships with them, as well as our funding Know Your Rights training, as well as family planning, right? Like for families to be able to know if something happens, how do they get the resources that they need quickly and be able to help their family. Our office leads with language access, making sure that inclusion is centered in what we do, and making sure that folks in our community feel like they can belong. And our mayor has been clear on that too. And since making sure that he's recommitted to the city of Seattle's welcoming policy. Both the mayor and our city attorney are prepared and committed to defending our welcoming policies that ensures that we don't ask citizenship questions in the city of Seattle. And so just so you all know, we will continue to stand for our values and protect those policies in the best ways that we can. And so with that said, I hope today's training provides you with practical tools and that you're able to refocus, reconnect, meet with each other and network. And if you have follow-up questions, we are here to figure out what else there is that we can help support you all in these really challenging times. And so with that said, now I will kick it over to Oksana to let you all know what is happening, do some housekeeping information, and then kick off the training. Thank you for the time.
Thank you so much, Hamdi. I'll start with a few housekeeping items. So as you see, our main door is now closed, but people can still come in and out through that side door right there if you need to leave before the event is over. Also, the bathrooms are located right there. You can leave the room right by the stairs on my right, your left. There is an exit door where most of my team members are standing and pointing to, and that will take you straight to the bathroom. We have water and we have snacks. We acknowledge that we scheduled this meeting over the lunchtime, and if you brought your lunch, feel free to eat here. Of course, be respectful of the place when you leave it. We will be taking your questions after each presenter is done with the portion of the presentation. But we will do so through the little QR code that most of you should have received, and there were some available on the chairs. So if you have a question related to the presentation that's happening, feel free to scan that QR code. I will have access to those questions submitted and we'll be reading them. So apologies if we cannot get to every single question submitted. We'll try to summarize them. And also, we did receive many of the questions that have been pre-submitted to us and have shared them with our presenters today. You know that the registration was required for today's event, and that's so we can collect your contact information and can follow up with you after the event. So we will be sending out some of the materials that are covered today in this session in the follow-up email. Also, this session will be recorded and will be shared on our OIRA website afterwards. If you came in later and did not have a chance to check in with our check-in desk, please do so maybe afterwards so we know we have your correct information. And with that, I will just present to you my two panelists here today from the Northwest Immigrants' Rights Project. We have Malou Chavez, Executive Director of Northwest Immigrants' Rights Project, and Hwang, who is the directing attorney. And we are now ready to go to the part one of our today's event. Oh, and just so you know, we have 2 hours for this event today. We'll try to end by 2, but of course we started a little bit later, so hopefully it's not a problem if we go a little bit later. On to you, Malou.
Can you hear me okay? All right, I know that there's an echo, but hopefully you can hear well. My name is Malou Chavez. I serve as Executive Director of Northwest Immigrant Rights Project, a statewide legal services organization. We provide services to clients coming to us from over 150 countries, speaking more than 65 languages. Our staff collectively speak more than 27 languages. We are here to provide immigration legal representation, services, legal clinics, presentations like the ones today. And this is through both direct legal services, but also through our community education. And last, we also do systems change work, which includes impact litigation and legislative advocacy, both for community members who are in Washington State, but our impact is across the country. I'll talk a little bit about some of the litigation that we have going, but I want to acknowledge that as an attorney, I use legalese sometimes and words that are in immigration law complicated. Feel free to chime in and say, what does that mean, or whatever. Maybe a follow-up question. Feel free to also ask anything for clarification or information. And of course, always feel free to reach out, and I'm excited to be here with all of you. I thank our partners at the Office of Immigrant Refugee Affairs, the Public Library, and others. All of you, I'm sure we've connected somehow or some way. Thank you all for supporting our communities. Thank you. So today we're going to discuss who is at risk of deportation and what to do, just briefly. I know there's a lot of information. We're also going to discuss some basic concepts of immigration law and provide some latest updates. As you know, there's a lot happening, so I'll try to keep it short, but try to touch on a few of the things that have been happening with our communities. Before we start with updates, I wanted to ensure that there's some common knowledge about who we mean by immigrant communities. So we have people who are U.S. citizens and either born in the U.S., naturalized, or acquired or derived citizenship through a parent, for example. And then we have immigrant community members who are considered non-citizens. And we have lawful permanent residents, asylum, people who have sought asylum and are now considered asylees, people who have refugee status, people with temporary legal status, which includes students on visas, temporary workers, people with deferred action, people with U visas, temporary protected status. There's multiple different temporary status that a person can have. And then we have immigrant community members who are not in lawful status and often considered undocumented. Either they entered the country with a visa and have overstayed, or they entered with what's called without permission. The reason why I want to introduce this to you all is to understand that immigration status is fluid. One person can go from being undocumented to being documented. Likewise, a person can go from being documented to potential risking their status and losing it. So it's very important that we keep in mind that our community members come to us as service providers with different experiences and with their status varying depending on their own situation. So who is at risk of being arrested by ICE? So first, the law permits enforcement of federal laws against any person who's undocumented and people with legal status, so lawful permanent residents or other status like the temporary status that we mentioned, who have encountered the criminal legal system and have criminal convictions or offenses. We'll talk more about how this is expanding with this current administration. The highest priority seems to be people who are non-citizens with prior orders of deportation, so removal orders, where they've gone through the process and a judge has ordered them removed. Maybe they were ordered removed at the border. Somehow there's a final order or there's a prior removal order that impacts their status. Also, priority seems to be people with criminal histories, but remember that all non-citizens are at some risk, especially people without any lawful status. And also, as a priority, it seems to be that non-citizens who are subject to expedited removal enforcement. And what this means is people who have been in the country for less than 2 years. The federal government has authority to stop anyone who's not been continuously living in the U.S. for more than 2 years and can do a process called expedited removal to be essentially detained and then deported without the ability to see a judge and defend their status. And we'll talk more about how that has changed in a minute. But I know I said that all people who are undocumented or without status are at risk. There's a difference here that not all immigrants are vulnerable to deportation, right? And so Again, immigration status is fluid. There are definitely two groups of people that the government is going to pursue enforcement against, but people with status are not necessarily vulnerable to deportation. Most people have the right to have their case heard before an immigration judge. There are exceptions. I mentioned the expedited removal group of people who can be expeditiously removed. These are individuals who have been in the US for less than 2 years. And one thing that the administration has done, it used to be that it would be within 100 miles of the border. Now they've expanded their authority to be anywhere in the US. And we'll talk more a little later, but it's also including people with permission who have been paroled to the country. Exceptions to seeing an immigration judge also exist for people, again, who have an order of removal, and people who enter the country without a visa. So these are specific countries who are given visa waiver, a waiver to not require a visa to enter. And these group of community members do not have the ability to see a judge, immigration judge. Again, I mentioned that immigration status is fluid. There are many types of immigration statuses that protect against deportation for a temporary period. So some of you may be familiar with Deferred Action for Childhood Arrivals, DACA, people who entered before they turned 16, a program, and we'll talk about this later, program that was announced in 2012. There are people with temporary protected status, specific countries that are designated because the person is not able to return to that country due to some, for example, civil or environmental issue. And then we have more recently, some of you may be familiar with a protection that was announced in 2023 or 22, I can't remember, time is very strange right now, for workers who were subject to violations by an employer. So this is DALE, Deferred Action for Labor Enforcement. That lasted very short. It was a very short protection. But many of our community members who were engaged in investigation against their employer for violations, work violations, were able to be protected and receive temporary protection from deportation and work authorization. And this is temporary status. As long as it's valid, it continues to be temporary. We use the word status and protection, and then we use the word work authorization. In immigration law, not all of it means the same, but feel free to ask any questions if you are needing clarification. One thing with lawful permanent residence, someone with lawful permanent residence status remains a lawful permanent resident unless there is a procedure before an immigration judge or they sign a form rescinding or withdrawing their status, like giving up their status. Other than that, lawful permanent resident status cannot be taken away without a particular reason, and typically is due to a criminal conviction. And the person has to be placed in that process to see an immigration judge, so then the judge can decide whether the person retains their lawful permanent resident status or it's taken away. So what can one do if at risk of deportation? I know that some of you or all of you have attended presentations around Know Your Rights. Important to remind our clients, our community members, our families, our neighbors, the right to remain silent, to speak with the lawyer, and to not let immigration officials enter private spaces. You'll learn more about this with Henry's presentation. And also, the right to not self-incriminate. It's not listed here, but there are many rights that apply to people regardless of their status, immigration status. And the rights can be invoked in any language. Another thing that we say in order, what to do is to make a plan in advance with family or other trusted people in their lives, especially when there are children, minor children involved, when there are situations where someone else needs to come in and take care of decision-making, for example. Definitely avoid contact with submitting applications for immigration purposes without consulting a legal advocate or a lawyer, or visiting offices like U.S. Citizenship and Immigration Services for information, right? Because right now, in the times that we're living, anyone, again, is at risk, and there could be questions, right? And avoid contact with criminal legal system. We'll talk about a change that has happened in this administration. And the other thing that we say, it would be good, because I mentioned the expedited removal process where a person doesn't have the right to see an immigration judge for people who are living in the U.S. less than 2 years, it would be good to carry evidence of 2 or more years of presence in the U.S., including filed applications. So like a receipt notice would be good to carry. Our Washington State IDs would also be good to carry. All right, so there's a lot of information, but I wanted to also summarize deportation proceedings. So this is a process to determine if an individual should be deported from the U.S., and there are typically 2 questions that are asked. Is the individual subject to deportation? If so, do they have a defense to deportation? So how do people end up in removal? Either they're detained at the border when entering. Often they're entering pursuing asylum because they're fleeing a specific situation in the country that they were coming from. They're identified by ICE, Immigration Customs Enforcement, or Border Patrol, or are arrested by local law enforcement for a different reason. One thing that you'll learn later is in Washington State, we have Keep Washington Working Act, but Keep Washington Working Act is around collaboration and data collection by law enforcement. It's not about whether they can arrest someone for a criminal reason, right? So the law enforcement agencies can still detain or arrest someone for a criminal reason, not for civil immigration purposes. I know I mentioned that typically people have the right to see a judge. Some people may not get a hearing before a judge. And I want to show you the different processes that someone can be going through when you talk to them about their situation. Of course, if they want to share, also just a caveat, don't assume that someone is going through an immigration process, right? Don't assume someone's immigration status as well, unless they're applying for certain benefits with your organization. But someone who is at risk of deportation can be going through what's called 240 proceedings. This is before a judge. Typically, this is the most common way that people get in deportation proceedings. We talked about expedited removal for people who have lived in the U.S. less than 2 years. Anywhere in the country, there could be at risk. And then there's withholding-only proceedings for people who have had a final order in the past, but they fear returning to the home country. And this is a very limited proceedings, but it's before a judge. And then last is what's called bond proceedings, which is almost like bail. You pay a certain amount to be released from detention. These are different proceedings that a person can be going through in deportation proceedings. Someone can also be going through what's called seeking affirmative protections with the benefits agency of the Department of Homeland Security, which is the U.S. Citizenship and Immigration Services, and not be in deportation proceedings. So there are many things that are experiences in the immigration context that our client communities are experiencing. In Washington State, there are 2 courts in Seattle and Tacoma. It's important to know that there is generally no right to counsel in immigration court if the person cannot afford a private attorney. And this means that many people are forced to represent themselves. At Northwest Immigrant Rights Project, we provide services. Often we take on the case for full direct representation, where we go with the person to court, or we help them submit forms and applications to USCIS. But again, this is a very limited situation where the need is greater than the capacity. And so here we are. These are the updates I think you've been hoping for. Again, feel free to ask any questions using the QR code. The main thing that this federal administration has been pursuing is a call for mass detention and mass deportation. And you have seen this through various ways. I mentioned that there has been, with this federal administration, that there have been changes in the criminal process where someone can be subjected to immigration enforcement. Earlier this year, the Laken-Riley Act is a bill that was signed into law that says that certain people who are immigrants and undocumented, if they are accused of a specific crime, including shoplifting, then they may be forced into mandatory detention in immigration custody without the possibility of applying for bond or bail to be released from detention. And this changes because in the past, it used to be that a conviction was required, or that someone needed to admit to the elements of a crime. This completely changed to arrest or charge of a crime. But again, it's very specific crimes: shoplifting, theft, assault of a law enforcement officer, death or harm, great bodily harm to a person. But this is important because earlier in the slides that I presented, one of the things to do is not to get into the criminal legal system, right? Because what happens is sometimes people who get arrested and convicted get entered into a database that Department of Homeland Security has access to, the Federal Bureau of Investigation's database, FBI database. And so very important to know that there's a change, and shoplifting and theft, very minor offenses, can lead to very drastic consequences for a community member. We also know that there's been an increase in interior enforcement, recent arrests, students' visa revocation, returning of lawful permanent residents at the port of entry at the airports, in violation of the First Amendment. One thing I didn't note here, because when we worked on this presentation, we hadn't seen that large-scale raid that happened in Bellingham. That was the first time a large-scale raid happened in Washington since the start of this federal administration. And we want to make sure that, again, we go back to what we know. Know your rights. Don't carry documents that are not U.S. issued. All these different things. Carry your receipt notice if you have pending application, right? But sometimes there will be situations when no matter how much you invoke your rights, carry all of that, ICE might still apprehend you and detain you. And so then the removal proceedings start, right? How do you defend, or can you defend your status? The other thing I want to mention about interior enforcement is that, as I mentioned, detention expansion is a key goal of this administration. Tacoma has one of the largest immigration jails in the country, is one of the largest immigration jails in the country. And right now we have more than 1,400 people detained. The capacity is 1,575 people. The other thing that we have been seeing is an app that had been created for asylum seekers at the border to intend to seek asylum, what was called CBP-1, has been converted to CBP Home, and it used to be a scheduling tool for asylum purposes. Now it's used as a tool to facilitate a person's self-deportation. Some of our community members who have this app on their phone, it's important that they know that there is location sharing, and again, there's DHS has access to this information, right? So very important information that, again, there's a lot of information, but whatever you learn from today's session, I hope you are able to share with community as you work with them. The other thing we're seeing is that immigration enforcement used to be conducted by ICE and CBP, Immigration Customs Enforcement, Custom Border Protection, and USCIS officers sometimes, right? DHS, Department of Homeland Security. But we know that other agencies have been deputized for enforcement, including FBI, DEA, and you have learned potentially that IRS has been asked to potentially share information, not yet. But yesterday's arrest, we saw military officers arresting people in Bellingham. And so this is being expanded beyond the typical officials for enforcement. The asylum seeking process, we know that there was a ban that became effective on January 21st, suspending entry of people at the US-Mexico border. And all of these came through either executive orders, memos, right? And again, I mentioned the CBP One app. That app has been disabled, so people don't have that option anymore. There's also an ask for people to remain in Mexico. But the process for people who are able to enter the country or are in the US, they can still pursue asylum. It's taking a long time to even get to the end of the process, but it is something that's happening. We know that other ways that asylum seeking has been impacted is in claims. Our LGBTQI plus community is impacted, where a claim based on being a person, a transgender person, was seen as a potential protection. Now, asylum officers are being asked not to use that term, for example. So we have to be strategic about how we protect or help our LGBTQI plus community members to seek asylum, for example. So there's a lot of changes happening within asylum. The other thing is around the refugee program. It was suspended, and many agreements for refugee resettlement agencies were terminated. There is an injunction that was issued in February. The other thing that's been happening is through an executive order, there was a national emergency. There was also something called the A-Word Enemies Act that was invoked on March 15. You may have heard in the news, sending Venezuelan community members to a prison in El Salvador. And one thing that's happening locally is that Northwest Immigrant Rights Project and partners across the country have filed a litigation or a lawsuit against this process of sending people to what's identified third countries, a country that had not been originally designated in the removal process for the person. The government can't do that without the opportunity for the person to apply for protection under the Convention Against Torture. It's very complex detail, giving you too much information, but what I'm trying to convey is that all of this is very difficult for someone going through the process, but there are changes happening pretty rapidly, and so we're trying to keep up to date with as much as we can. We know that there are restrictions in public benefits provided. Many of you know, if you're working with benefits in immigrant communities, that we have specific benefits, federal benefits that are limited to people in lawful permanent resident status 5 years after becoming a lawful permanent resident, right? So not much change there. One thing that it's another goal of the administration is to create fear and to create confusion. But one change related to benefits is that the Deferred Action for Childhood Arrivals, DACA, had been added to the ACA, the Affordable Care Act. There's now a push to remove DACA recipients from receiving that. And so there are some changes being proposed, but I wanted to flag this, that lawful permanent residents with 5 years or more continue to be eligible, so that has not changed. There are in other parts of the country expanding what's called 287G agreements for enforcement collaboration between law enforcement agencies and immigration enforcement agencies. That is not the case for Washington State. Again, we have something called Keep Washington Working Act that prohibits that collaboration for civil immigration enforcement. We also know that there's been protections being revoked. There were memos in prior federal administrations like trauma-informed approach when working with survivors of violence in enforcement action. That's been withdrawn, and you probably heard about the safe locations or secure locations. That memo was withdrawn, right? There's a lot of protections being withdrawn. And by protection, again, it's not a status, but it's a practice that the federal government had in the past that's being taken away, and again, creating chaos for our communities. I know that there were questions from the audience around what's called categorical parole programs. So these are parole, meaning permission to be in the country for specific countries, people from specific countries. So Cuban, Haitian, Nicaragua, and Venezuela had a specific parole program that was created, and with the change in administration that had been phased out but essentially ended, it ended. Now there's also a pause on United for Ukraine and family reunification parole. Also the parole that was allowed for Afghan community members was also paused. And what this means is that people who are not yet impending immigration status are at risk. And we talked about expedited removal. These are also community members who might be at risk of being removed without the opportunity to see an immigration judge. Another thing that's happening with this group of community members is that the petitions or applications that they can submit based on being given parole are on pause. They're not being adjudicated. And so someone who would be pursuing asylum or adjustment of status to get their green card, they're not going to have those applications adjudicated yet. So there's some changes happening. Even for people who are eligible to pursue lawful status, those are being paused by the administration. You also know that one of the first executive orders was around the birthright to citizenship. And fortunately, within a week or so, that was stopped, so it never became effective. Northwest Immigrant Rights Project and the Attorney General in Washington had a case, and each had a case, and then they merged. Our case was for 3 mothers who were impacted, who would be impacted, and so right now that case might be heard before or there was an ask by the government to hear that case before the Supreme Court. So we are still waiting to see what happens there. The other thing that has been happening that may be impacting you or community members or someone you know is that there has been high scrutiny in travel, even again for people in status or documented status. So lawful permanent resident, so green card holders, visa holders are at risk. That important to, sorry, I'm just gonna look at my notes real quick. Important to remember that when someone travels, if whatever document they're traveling on, if they're not a US citizen, even if you're a US citizen and you might have dual citizenship, important that all of the documents are valid during travel. So sometimes people travel with like 3 months and it might expire during your duration of travel. That's very dangerous right now because what that might cost is secondary inspection. If someone's not a lawful permanent resident or citizen, they might even face other challenges. The rights of lawful permanent residents continue. You may have seen green cards that have a 10-year expiration date. That's just for the card. Lawful status continues, again, unless a judge removes that status or the person signs a form saying that they don't want to be a lawful permanent resident anymore. We have heard of immigration officers at port of entries almost pressuring people to sign these forms. It's a form I-407. Very important that people are not required to sign those forms. So if you hear of anything, please notify that community member that that's not required. And one thing for lawful permanent residents is that travel should be within less than 6 months a year outside of the U.S. Because they need to be able to prove continuous presence in the U.S. And it would also avoid a claim by immigration officials of abandonment, right? So again, travel scrutiny. One other thing that people are advising on is your phones and your computers having good hygiene, what information is out there for officers to look at, right? And I know I'm running out of time, but I'm gonna just move us along real quick. We talked about temporary protected status, and there has been a temporary restraining order that for Venezuelan community members who had TPS, yesterday was the last day that they could have filed, but people who had expired employment authorization, that gets automatically renewed. Again, I know IRS communication with immigration enforcement is in the minds of people, whether they filed taxes using their individual tax identification numbers. We are not tax experts. We cannot advise on that. Some people are pursuing extensions, but I know that this is another concern that our community members are having. And then quickly, for DACA, Deferred Action for Childhood Arrivals, there was a recent Fifth Circuit decision in January that said DACA recipients are allowed to continue renewals. Some DACA eligible people can submit initial applications, but those are not being adjudicated that we have heard. And one good thing about this decision is that DACA recipients were deemed low priority for deportation. But again, remember that criminal legal interaction, very important not to fall under one of those groups that would be targeted for apprehension if in the event that they have temporary status. This is another important message to share around registration. Registration of people, community members who are undocumented, not everyone. It's it has happened in the past. There is a statute that provides for this to happen, but it's unprecedented in the way that it encompasses many people, but not every undocumented person is required to register. This is a tool for immigration enforcement. It's not a tool for benefits. So it's important that no one submits this, at least not until it becomes effective. It becomes effective on April 11. Nobody should be submitting this unless there are legal advice that they have received. And the dilemma for community members is, do I register and add my name to a list for potential deportation? Or if I fail to register, am I potentially going to be penalized criminally, right? Prosecution. There's a challenge right now against this going through, so we will keep you posted on what that looks like. I have some resources here that you can look through, and I hope that you got a lot of information. I know that we have 2 more presentations, so I'll see if there are any questions briefly, and we can always come back. Yeah.
Thank you, Malou, so much. We received a lot of questions already. So a reminder, if you have a question, please use the QR code. Also, we've been handing out blank papers, notes, and pencils. If you cannot use a QR code, please flag, and one of our team members will come and collect that paper with a question on it. My colleague here, Bilkisa, can collect it, so just please flag her. So, Malou, I'm going to ask you a number of questions, but again, apologies if we cannot ask all of them, and hopefully you can give a brief answer. So there is a clarifying question. You said to be careful when submitting applications to USCIS or in general interacting with them. Can people still go to their website and download forms? Is that being tracked?
Oh, thank you.
Somehow?
I don't think that's tracked. They might not be tracking the IP address of where you're accessing the websites. I think it's more if they know identifiable information like your name, your address, your phone, right?
Okay. Next question about expedited removal. So you mentioned something that people who have not been physically present in the U.S. for the 2 years should be carrying documents or who have been. Does that expedited removal apply to people who have a green card? If they have not lived here for 2 years, can they be expeditiously removed?
Thank you so much for that question. No, it does not apply for people with status, and lawful permanent residents or green card holders have status. So it's for people who are undocumented or with parole who have lived in the U.S. less than 2 years.
Okay, there is another question about information sharing between different federal agencies, and you mentioned concern about IRS potentially cooperating with ICE. What happens to people who submit their college applications with FAFSA and WASP?
Yeah, and thank you. FAFSA and WAFSA, what happens to people who submit information? I know that's a concern. Ultimately, it had been a concern before this administration too, that you're sharing information potentially of your parents who may be undocumented. Ultimately, it's a decision of the person and their parents. We haven't heard of any enforcement that happens from that. I know that state agencies are looking into this to make sure that that's not, and I know the governor's office has reached out to NWIRP to see if we know of any people who have encountered some sort of enforcement. We haven't, but ultimately it's a decision of the person.
A clarification on the birthright citizenship. Would someone born in the U.S. in the 80s be at risk?
No, the birthright to citizenship executive order was meant to be prospective, so in the future, and it had a date that anyone born on or after that date would not be citizen. So it wouldn't apply to someone before that date. And again, it's a stopped order, so it's not continuing right now. There might be a decision coming up from the Supreme Court.
I'll let you catch your breath for a second. There are a lot of questions coming about the slides from today's presentation, if they will be shared and available, and the answer is yes. Of course, we'll post them on our website, but also those will be emailed to you. So it's great that we have your email addresses through the registration. A question about criminal convictions. Are all of the crimes equal, or is ICE going after people with certain specific convictions? So, for example, fraud or assault?
Yeah, it's difficult. In Washington State, at least we're in a better position than in other states where there is collaboration with law enforcement and immigration enforcement. There are certain convictions that someone with lawful status could be at risk of facing deportation proceedings. Some convictions that are minor offenses, for example, may not trigger that attention from immigration enforcement for deportation proceedings. So, in short, no, not all criminal convictions are seen the same.
Question about parole. So you said that people who are in parole status could be subject to expedited removal. would it be before or after their status expires? And can they travel within the country still?
I know that they're targeting people with expired parole for sure, or people who are placed in deportation proceedings or subjected to expedited removal. So remember, it has to be within the 2 years, right? So if someone who entered with parole has been in the U.S. for longer than 2 years, then they're not going to be subjected to expedited removal. But we have seen people with parole not yet expired be apprehended. So travel within Washington state might be okay. I don't know about other states, so it's a risk.
Clarification about question about USCIS website. I think that when they submitted the question, they meant logging into USCIS website to your own account and doing a search in there, if that's going to trigger any.
Thank you. So My USCIS is the name of the website that people have access to in order to file forms or check status of a pending application. I don't know that they track if you log in, potentially. It might say last logged in. So they already have your information is what I'm trying to say. So, yeah.
And there was a similar question if filing FOIA to get copies of your immigration applications gonna flag you for anything.
That is something that we recently learned, that is another way for enforcement. It's always been accessible to Department of Homeland Security, right? Because you're submitting a request for your file or the person's file and providing your address, where you want the file to be mailed or the email. So one thing that's being advised now is the address that the person uses, physical or delivery address, to be something different. But it is a risk. Again, I think this particular administration, the goal is enforcement. So, yeah.
Could you please clarify whether application for adjustment of status for refugee is entirely suspended or only restricted in certain cases?
I don't think it is suspended for refugees. Is it, Henry? Refugee adjustment of status? Is that?
Yeah, right now that there are reports that they're being suspended.
Okay.
Meaning they're just not actually adjudicating, they're processing them. They're accepting them, but I don't think we've had anything that's actually, on paper. These are more rumors and reports.
Thank you.
Okay. For a person who has come here in a legal status, but since had a heavy contact with legal system, and it's written here, does applying for Social Security benefits when they become eligible for retirement, for example, would that trigger if they are deportable or not?
They came with status?
Yes.
I don't think so. It depends on the type of status. I think that they should continue to pursue benefits that they're eligible for, unless the criminal conviction makes them deportable. So there are certain convictions like domestic violence assault, for example, that would make a lawful permanent resident deportable.
There are several questions about detention in Tacoma. So one question is if we know if most of the people who are detained in Tacoma are from our state or from out of state. Also, is there a guarantee that people who live in Washington will only be detained in Tacoma, or can they be moved to out of state, or can they actually be moved to El Salvador or any other country like we have seen happening? Maybe Henry?
Go for it, Henry.
Yeah, I'm happy to take this. This is only anecdotal reporting. We have colleagues that run a legal orientation program in Tacoma, so we regularly see the detained population there. And I actually asked the same question about what's the percentage between people that are coming from out of state, which historically that's been the case. People that were caught at the border, but they were sort of transferred to Tacoma. Those were the majority before. But my colleague said it seems like well over 90% are based on arrests in the state of Washington. As to the second question about transfers, it is definitely possible. We've seen this in a lot of other cases, particularly if you've read in the media about some of these students that were recently arrested, then sort of moved around and almost seemed like extraordinary rendition or something. That can happen, but historically we have not seen it happen for the detainees in Tacoma.
So a question related to public charge. Has anything changed with public charge recently? And is it safe for asylum seekers to be receiving benefits?
Yeah, thank you. No, nothing has changed to our knowledge. There's always an analysis that happens when a person is applying for admission, and applying for a green card is considered an admission. Nothing to my knowledge has changed around public charge. For someone, asylum seeker adjusting, is that the question?
They're just asking if they are receiving benefits, is it going to endanger their status?
Oh, no. Benefits in general does not trigger finding of public charge. It has to be someone who is relying on government for their survival, right? For their subsistence. So no, it's or committed under a medical. I'm forgetting the terms. In immigration law, there's very specific terms. But no, general receiving benefits that someone is eligible for will not trigger public charge inadmissibility.
Are non-citizens obligated to allow data searches at the port of entry? And before one of you wants to answer that question, I'm going to say that our office is planning to do a similar event about all things intersection of civil rights and immigration. So traveling across the border, also a right to free speech, and what happens with international students in United States. I see a number of questions related to international students in colleges in Washington, if we have seen their visas being revoked or are they in danger. So if any of you want to answer it.
Yeah. So both citizens and non-citizens are subject to that search. The difference is that citizens and lawful permanent residents have rights to enter. A non-citizen with temporary or parole or advanced parole traveling may face additional challenges if they refuse a search.
And I think there seems to be maybe a little heightened caution about maybe even renewing people's green cards. At this point, for people who have their green cards expiring, do you recommend renewing them?
Yes, it depends, right? Someone who has a green card expiring, remember, it's the card that expires, not the status. But green card holders are required to carry their green cards with them. So unless there's a criminal conviction that would make someone deportable, or there's fear for specific, and they've gotten legal advice, I think the general advice is to continue to renew unless there's something that might trigger something else.
And this is going to be last question before the next presentation that's related to your answer, and this is about what documents people should carry and who specifically. Can you please explain it? Because I think there is also concern about the 2-year expedited removal, you saying now green card holders should carry their green card. And then there's a question, should DACA recipients be carrying documents with them, and what documents? Yeah,
the general requirement, not that everybody does this, is to carry the document that proves your status, right? Some people make copies, like paper copies, and carry that in their wallet. Others carry the actual card, like green card, employment authorization card, even receipt numbers or receipt notices that has information that there's a pending asylum application. So those are the type of documents that might help in a situation where ICE might be targeting the person for enforcement. But again, we can't guarantee that there will be no violation. We've also know of enforcement against U.S. citizens, right? And we've had a U.S. citizen detained. So there's definitely risks that the burden is on immigration to prove that you are not a U.S. citizen. So unless you are affirmatively saying, I'm not a U.S. citizen, or I was born somewhere else, remember your rights to remain silent, to not show any documents. You do not have to show your documentation or allow the search of your person without a warrant. And we're going to get into this with Henry's presentation, but essentially right now it is a heightened fear that anyone, and there's going to be a lot of racial profiling too, right? That anyone who might be, according to the officials, immigration officials who might be considered to be not a U.S. citizen might be targeted. So. Thank you so much, everyone.
And I know there. Thank you, Malou. Henry will now talk about best practices of serving immigrant communities. And I acknowledge that we have more questions than what I was able to ask, so we'll try to answer as many of them as we can after that presentation, too.
Thanks, Oksana. Yes, my name's Henry. As you guys heard before, I want to thank the Office of Immigration and Refugee Affairs for hosting this, along with the library as well. And I'm really happy that so many of you guys are here. I heard Commissioner Mohammed talk about how you guys are sort of frontline service providers, but I actually think that really you are frontline defenders, right? Because in ICE encounters, you are going to be the person who's there with the best chance of safeguarding your own staff and your own clients. So I think you should try to get into that mindset in the face of what we're seeing these days. But very quickly about that last question about documentation and what you should carry. It's very difficult for us to say what documents will make you safe, right? If you're a green card holder, by and large, carrying your green card is a good thing. But for everyone else who's undocumented or has different types of status, I really recommend that you speak to an attorney because it will depend on your specific situation and they will tailor the advice to what makes you the most safe or your clients the most safe. But that said, okay, here's a quick roadmap. I know that we have not a whole lot of time, but I am going to be talking a little bit about ICE, the Fourth Amendment, a little bit about the Fifth Amendment as well, public and private spaces, and then practical advice, since you guys are mostly service providers. And that will be sort of in 3 stages: the sort of planning that you can do to protect your clients, then sort of enduring is what I called it, what happens when ICE is actually there, and one very sort of important part, documenting what happens if you ever have an ICE encounter. Now, the purpose of this is really to help you think of how to continue to serve our community members in sort of a safe and smart way. There is a lot of fear, uncertainty, and chaos. We've heard this with Malou's presentation, and this is absolutely intentional by our government. Even though the government has touted its sort of enforcement efforts and all the numbers that they have of people detained and people deported, the truth of the matter is they don't have the money or resources to deport every undocumented individual from the United States. So what they're doing is creating a strategy, or they're following a strategy, I should say, to create sort of this atmosphere of fear and intimidation, okay? And the hope is that they will then make people so desperate that they will self-deport, that they will use that app that Malou had been talking about and just leave the country. And in fact, it is working. We have seen this with people and community members. So in the face of this, I think that going back to that idea that you are frontline defenders, remember, you and your staff and our clients all have these rights. We have these constitutional rights. And the saying is absolutely true that knowledge is power. So it's in our interest and it's in the interest of our own clients that we exercise these rights, that we educate our clients about their rights in the face of this terrible, intimidating tactics. Okay, so as you can see from the slide, we believe that nonprofit agencies and service providers should protect their clients and staff to the greatest extent possible during any ICE interaction. Now, you can accomplish this by doing 3 key things. First, establish clear protocols for ICE interactions. These will be the practical steps that your staff will understand and be able to easily follow anytime ICE comes to your office or workspace. The second thing is assess and audit your workspaces and your event sites. We will be discussing how your protections can sort of change depending on your location, or at least your constitutional rights. So it will be important for you after this to really think about where you work, where your clients are, and how you will arrange things so that your clients and your staff are best protected. And finally, training your staff. Even if you have clear protocols and you've sort of sussed out your work sites, if your staff is not informed of their rights and responsibilities, then you are absolutely placing your staff and clients at unnecessary risks. So this presentation really is just a starting point, okay? And your sort of action items to follow will hopefully follow these 3 broad steps. So what is ICE? ICE stands for Immigration Customs Enforcement. It is an agency of the Department of Homeland Security, and it's tasked with enforcing and maintaining immigration laws. This is not unlike how police are tasked with enforcing criminal laws. Now you'll see from the photos that while sometimes ICE will be in uniforms and clothing that might say ICE or police, it might even say ERO, Enforcement Removal Operations, or I don't know, HSI, Homeland Security Investigations. In other instances, they may have clothing that only says police or even just be in plain clothes. You might recognize that photo in the bottom right-hand corner there. This was an ICE arrest of a Tufts student on her way to break Ramadan fast, and this was just last week. Plainclothes officers surrounded her and arrested her. And it was certainly a very scary and disturbing scenario. Videos of this are available. That's actually just a screenshot. So sometimes they just look like ordinary citizens walking around. But at the other end of the spectrum, but equally terrifying, ICE agents might be wearing tactical gear. They might be heavily armed, almost virtually indistinguishable from military agents. Now, all of this is to say that ICE encounters can be very intimidating. So when you're thinking about preparing for an ICE encounter, you have to think about this broad spectrum of what might be coming into your work areas, right? It could be plainclothes folks, but it could also be a group of men that are in camouflage, heavily armed, and it's really terrifying. But in the face of this, as we said before, you do still have protections, and you have to remember these to protect yourself, your staff, and your clients. So let's talk about some of these protections. Now, when we're talking about ICE encounters with service providers, we typically rely on the 4th Amendment to the Constitution. This protects us against unreasonable searches and seizures of people and property by the government. And the government here, of course, includes ICE. Now, importantly, this protects both citizens and non-citizens. So undocumented immigrants have this constitutional protection in the same way that citizens do. So they can invoke their rights when encountering ICE. Now, as a service provider, whether you are a citizen or non-citizen, you can and should invoke this constitutional right during an ICE encounter. However, the extent to which your workspace or your clients are protected by the 4th Amendment depends largely on the location of the search and seizure. Now, you'll recall that I just mentioned talking about assessing your work sites. I said this, and we'll see this on the next slide actually, how there's a distinction between public and private spaces and how your rights are affected by where you are during an ICE encounter. Okay, so here is that distinction. When you're thinking about the 4th Amendment, we have this sort of private and public dichotomy. And you can see from the chart here that I've sort of divided the boxes between the public and private spheres. Now, private areas are those places where you have a reasonable expectation of privacy. Okay, the prototypical example is your home, right? Your home is your castle. This is a place where you expect to have privacy. And so in that sort of private area, that is where you have the strongest 4th Amendment protections. Similarly, in your workspaces, you probably have these areas, with signs that says this is for staff only. Those seem like very clearly marked. You don't expect people just to walk in there. Those are private areas of your place. And those should also enjoy strong 4th Amendment protections. By contrast, however, on the right-hand side, you can see public areas are those in which you do not have an expectation of privacy. So think about places like out on the sidewalk or on the street. These are all places where any members of the public can go out. I don't need permission to walk down the sidewalk because anyone can go there. Okay. Now, one way of thinking about the difference between public and private places is to think about access, right? Who can access these areas? In your home, only you can access your home and you let other people in. Whereas out in a park or on the sidewalk, anybody can just walk in. I don't need anybody's permission to drive down the street. So that's very obviously a public place. Now, given this distinction, the question becomes, what does ICE need to have to conduct a search and seizure in private and public places, right, when they want to make an arrest? So, in private areas, I've written this down, ICE must have one of two things. First, they have to have a proper judicial warrant, or they need your consent to enter a private area. They have to have one of those two things. Someone had said once, like, think about it as a vampire in your home. If you watch movies, vampires always need your permission to get through your doorway. ICE is in a similar way. They actually have to have your permission unless they have the other thing, which is a judicial warrant. Now let's contrast this with public areas. Public areas, ICE doesn't need your permission. They can walk around in public areas just like anyone else can. But if they want to make an arrest, they must have what we call reasonable suspicion. They have to have a reason to believe that you or the person they're about to arrest has committed an immigration violation. And finally, at the bottom of the screen, I did want to sort of point out this one exception, which is the plain view doctrine, where if you do have documents that are sort of out in plain sight, you should be careful about that, because that's information that ICE can seize. You know, I think about events like today, sometimes people have rosters and they have their clients check off whether they're coming in or not. You might want to rethink that, because that might be in a public area, that might be accessible, and it might be an easy way for ICE to gain some information. Okay, let's dig in a little bit deeper, and beginning with the private area consent. Now remember the general rule again for private areas. ICE needs either a judicial warrant or they need your consent to enter and search a private area. Now here are some tips bearing in mind that, you know, we are trying to protect our clients and staff to the greatest extent possible. So if ICE comes to your workplace, the easiest thing to do is just deny them permission, right? Simply say, I do not give you permission to be here. I do not give you permission to enter. Please leave. It's very simple. But I do think it is a good idea for your organization to identify and delegate the authority to provide consent for someone to come in. For example, you could let your staff know that only supervisors or a particular manager or even your director is allowed to give permission to law enforcement, including ICE, to enter your areas. Now, I say this because it sort of takes some of the pressure off of your staff during these encounters, right? And it's also a very easy rule to remember. Oh, if someone wants to come in, just call the manager, right? And they can tell them, you can't come in because the only person who is allowed to give permission is my manager. You'll have to wait. So consent does seem relatively straightforward, right? But please be aware of ICE tactics that they will use to gain consent. And of course, we're talking about using falsehood, lying, and using pressure and intimidation tactics. You know, if ICE is screaming, let me through or I will arrest you while they are heavily armed, it is a little bit harder to suddenly say, no, I don't give you permission, right? So this is why, as I mentioned before, training your staff is critically important, and even thinking about role-playing some of these scenarios. Okay, staying on private areas and repeating myself again on that general rule that ICE needs either consent or a valid judicial warrant to enter and search private areas. We just talked about consent. Now we'll look a little bit more closely at judicial warrants. Okay, now Bear in mind, though, in all likelihood, ICE will not have a valid judicial warrant. Okay, I would say that's probably a 90% certainty that they will not have one. Instead, if anything, if they do present a document, it is likely that it will be an administrative warrant that is issued by the Department of Homeland Security. So we have a picture here of two warrants, and the one that I've X'd out is that administrative warrant that's issued by the Department of Homeland Security. So there are sort of three telltale signs that you have an administrative DHS or ICE warrant. First, at the top, you'll see there, I've circled it. It says, this is the letterhead. It will usually say the Department of Homeland Security, or it might even have their seal, which is basically a circle with an eagle in the middle. Another telltale sign is the title. It will likely be titled Warrant for Arrest of a word, or Warrant of Removal/Deportation. Those are the two very common administrative warrants that ICE issues itself. The last sign is it will be typically, if you look at the bottom, it will be typically signed by an immigration officer. It might even say like a supervisor or something, but it will not be signed by a judge or magistrate. So if you see these sort of three telltale signs, then you have sort of an administrative warrant, which by itself does not allow ICE to enter a private area. So if you see this and you recognize these signs, you can just simply go back to that general rule. Well, this is not a valid judicial warrant, so what else do they need to get in? Well, they need consent. So at that point, you can just say, this is not a valid judicial warrant, and I do not give you consent to enter my building, and ask them to leave. Okay, so even though there is a very slim chance that they will have an actual valid judicial warrant, I do want to just go ahead and briefly talk about what you would look for in case they do. I say this because some of the reports of the arrests over on the East Coast of students, it was reported that they did actually have judicial warrants that were valid. So look for roughly 4 signs here for a valid judicial warrant. First, at the very top, you'll see that on the letterhead, rather than saying Department of Homeland Security, we see the name of the court that is issuing it. Typically, it will be a court like the District Court for the Western District of Washington, or maybe the Eastern District of Washington. The second thing, over at the bottom of the document, you'll see that it is signed by a judge or a magistrate. The third and fourth are sort of in the middle, which is you'll see that it will tell you the address and the scope of the actual items to be searched. It might have the address or even the name of the person. And finally, somewhere on that document, which is the second from the bottom, it will give you a time frame for how long that warrant is actually valid. Typically, they're valid for 14 days after they've been issued. So even if they do have what looks like a sort of valid judicial warrant, you still do want to read through it because maybe they have the wrong address. Maybe that this warrant has actually already expired. You know, maybe they were just too slow on their enforcement action. So if you identify that it's valid, absolutely take time to read the document. And like I said, it will likely describe the scope of what they can actually search. So in the rare event that they maybe do have it, and you find out, in fact, it is valid, it's still worth it for you to monitor what the ICE agents are doing and document. And if you believe that they are going beyond the scope of what is in that valid judicial warrant, I would object to it. I would tell them, I do not give you consent because this is beyond the scope of your warrant. But you know, in all likelihood, ICE won't have this valid judicial warrant, and so long as you don't give consent, they can't lawfully enter and search your private areas. Okay, moving on to public areas. So here, The Fourth Amendment protections are sort of not as strong as in private areas, right? But you still do have protections under the Constitution. And here's where we will sort of shift to invoking our Fifth Amendment rights against self-incrimination. Obviously, your right to remain silent. Now, in public areas, even though ICE can freely access these areas, right, they can walk around in these areas, they still do need reasonable suspicion that an individual is in violation of an immigration law in order to stop and detain them and arrest them. Now, this cannot be just a hunch, right? It can't be just walking while brown or something like that. Racial profiling is illegal, so ICE does need to have sort of specific and articulable facts when they're making the seizure or arrest. And this is why it's so important to invoke your right to remain silent, okay? If ICE has no information about you, then the only way that they can lawfully detain and arrest you is if they elicit the information about your immigration status from you. You are basically giving them the reason to arrest you, okay? So now, based on our experience, ICE usually does have information about targets that they want to arrest. They will know, they'll have a picture of them, they'll know their name, they'll know their legal status. So they'll expend a lot of money and resources to surveil this person and then go out and try to arrest him. But while they are doing that, they want to try to arrest as many people as possible. So people that happen to be around this person, what they call collateral arrests. They will go ahead and try to arrest more people to sort of bump up their numbers, right? And this, again, is why for people that they have no information about, that just happen to be near one of their targets, so long as they remain silent, there's a good chance that any arrest made by ICE at that point is illegal. Now, one of the questions we were asked were about Miranda rights, right? We know these from the movies and from television where a person's arrested and the police say, you have the right to remain silent. Anything you can say will be used against you in a court of law. You have the right to an attorney. They are giving them their rights in a criminal context. Unfortunately, courts have decided that immigration law is not criminal in nature. So ICE does not have any duty to inform non-citizens about their rights, about their Fourth Amendment and Fifth Amendment rights. So again, this is where it becomes critically important for you to take that role of educating your clients, because these are rights for everybody, citizens and non-citizens. And in the criminal context, the police will have to inform them of their rights during an arrest. But for non-citizens during an ICE arrest, ICE does not have to tell them. So it is, again, important for you to sort of take up that role of informing your clients about their rights. Okay, so now that we have sort of an understanding of the Fourth and Fifth Amendment rights, and in particular the Fourth Amendment and how it applies in the sort of public and private settings, we're going to move on to practical steps of ICE encounters. And this is sort of the preparing, enduring, and documenting stages. Now, knowing what you heard about public and private spaces, you should think about your own workspaces and your event sites and think about how to best protect your clients while continuing to provide services. My understanding is that we have a sort of wide array of service providers here. We have some in education, food services, many people in the housing sectors. And sort of because of this diversity, you serve your clients in a lot of different ways and in a lot of different areas. And so it's really up to you. You know your areas the best, right? So you have to start thinking about this sort of public-private dichotomy and how to create safer spaces where your clients and staff have more protections. And this is where we're talking about, you making that audit of your location. Now, if you'll recall, private areas are those where there is a reasonable expectation of privacy, right? Now, under the law, reasonable expectation of privacy is actually broken into two sort of parts, two components. This is how the courts have interpreted this. There is both a subjective and an objective component. So in your workspace, you might think, well, I know my workspace really well, and I think this is really private. That is your subjective feeling. The courts will say, well, actually, what's the objective component? What would an ordinary person looking in, would they think that that is a private area, right? So you have to satisfy both of those things when you're thinking about your own private spaces, your workspaces. And so to meet that sort of objective component, you should think about what clearly delineates a private space from a public space. So I will give you a few examples that hopefully some of you might find useful based on some of the questions that I was asked. Locked doors at the front of your buildings, or an intercom system, or even an appointment system with your clients can provide you with excellent protections during an ICE encounter, because it is making it very clear that wherever you're working, it is not at all accessible to the public. It is only accessible by appointment. It's only accessible through an intercom system after you've spoken with a person, and you can only enter these areas with either with a key because it's locked, or some sort of card entry. Now, sometimes locked front doors is frankly impractical for the services that we provide, right? But still, don't discount the effect of a closed door that's unlocked, but that has clear signage in front of it. So even if you have a public lobby or a reception area, you can still take steps to sort of demarcate your public area where anybody can come and people can come in from your private spaces where you work and where your clients and staff will have more protections. Now, a lot of this is about, creating barriers, closed doors, marking off spaces, or even creating sort of waiting rooms. Sometimes we'll have events that are in like hotels and other places. You should take advantage of the spaces that they have where they could create separate areas for meeting people publicly, and from areas that you create as a private area that's barricaded in some way, and that does not allow entry by the public. But recognizing that we are all service providers, by and large nonprofits, and sometimes due to our belts are always tight, basically. So maybe infrastructure changes are just not possible. You don't have the money or resources to do that. Or maybe you've just simply made the decision to sort of keep your areas open to the public because you do want to be welcoming to vulnerable populations. You can still, in these instances, provide helpful protections by thinking about those Fifth Amendment rights, right, about remaining silent. And here, of course, we're talking about making visible signs, having materials available that say, you have the right to remain silent when talking to ICE. You can educate your clients about these situations and about how they probably should not answer any questions when they're out in public from someone they don't know, particularly anyone who identifies themselves as ICE. So, and of course, when you're doing this, you should be sensitive to the languages of the populations that you serve. So even in public areas, even though we'd said you have sort of relatively weaker Fourth Amendment protections, you can still sort of lean on that Fifth Amendment rights and think about ways to promote that, to educate the community about that, and help them be protected. We did receive some questions about people who work with youth or at schools, and I'll just begin by saying that, in my opinion, the likelihood of a raid on sort of school-aged children at a school is really low, I think, particularly compared to homes or places where immigrants work. And frankly, in my experience with at least Seattle public schools, both my children went to Thurgood Marshall here in Seattle, and they had just really, frankly, excellent protections already on site. They had teachers and staff members that were present when students were coming in and out of the buildings in the mornings and the afternoons. Excuse me. They also have an intercom system where during school hours, members of the public are not allowed in, and they have to call in through the intercom system. And they also had fences around their playgrounds. So that was sort of clearly demarcating sort of this private area where people of the public can't come into this area. So now field trips are sort of a different story. I was asked about that as well. And I still believe that an ICE encounter in that situation would be quite low, but there's still at least 3 things that you could think about if you're serving children that are sort of on a field trip or some other site. First, you should, of course, remind the children not to talk to strangers at all. Second thing, you should have a clear protocol that if a stranger is asking questions, don't answer, but immediately notify your chaperone or teacher or supervisor. And the third thing is you could call the event space beforehand. Let's say you're going to a local library. You might consider calling that event space beforehand and asking them to just close it off to the public, for the hour that your children will be there. So there's absolutely ways that you can think about, blending both Fourth Amendment protections and Fifth Amendment protections in the context of school-age children. For housing providers, unfortunately, I do think that there is a risk that you and your clients may have encounters with ICE, particularly for targeted arrests. When we're thinking about the risks here, and some of those questions people had, about applying for benefits and addresses, how does ICE find me? Well, typically ICE has the address of one of 2 places, or both, your home address or your work address. So those are the 2 places that I think sort of have heightened risks compared to other places. So the housing providers, I really do think that you need to think carefully about investing in infrastructure, right, that would keep your community members safe. And here again, we're talking about those sort of locked front doors, the intercom system, card access to common areas, including stairwells and elevators. Because once you've sort of restricted this access, it becomes clear that your building is in a private area and that the only way ICE can enter is by having that valid judicial warrant or some sort of consent from someone in the building. I guess very quickly going down this list here, you'll want to have the established protocols that we talked about that are clear to staff, paying special attention to developing a communication plan that works for your organization or event. Remember that if ICE comes in, they can be sort of coming in hot with a lot of people. And so you'll want to be nimble in your response to that, and that includes having this communication plan where those frontline people that are at your reception, that are at your lobby, can quickly have support from your other staff members. And like I said before, the training of staff, of course, is going to be important here because if people don't know what to do, even if you have a nice written policy, it's going to be basically useless. Okay, I'm running out of time here, so I'm going to try to do this very quickly. ICE comes to your workplace or event. This is thinking about what if ICE is there. At the initial stage, you should very simply just ask for their ID and ask to see a judicial warrant. Because I'm thinking about this situation where you're a service provider and ICE comes in. Asking those 2 questions and following some of what we learned here today about warrants and following what we learned today about consent, you want to then, of course, safeguard your workplace by not giving consent to ICE to freely roam your private spaces. Because remember, they don't have that warrant. They could still gain entry by consent. Now, do not share any information about your staff or clients, right? If ICE asks you a question, exercise your own right to remain silent and just politely ask ICE to leave, particularly if they're interfering with your services. And one thing I do want you to be careful about, there could be a chance that you have a lot of clients that are still in the public area, let's say a waiting room, and you're concerned about them. You should not, lie, hide clients, or aid in their escape, because you don't want to run afoul certain legal liabilities. But I do think it is okay to audibly inform people citizens and non-citizens about their constitutional rights. You are not directing them not to talk to ICE. You are not directing them to act in a particular way, but you can inform them that they have a right to remain silent and that people don't have to answer ICE questions if they don't want to, and that they can talk to an attorney if they'd like to, okay? Now, I also have WISN up there. WISN is an acronym for the Washington Immigrant Solidarity Network, and they can provide support through the rapid response teams, which they do by sending community members very quickly to sort of give some support and document what's happening. I guess you guys can probably read the rest of this here, of what's on the slide, and it'll be shared, but I'll just jump right into the next one, which is then documenting the ICE encounter. Now, I want to do this by reading a description from this past year over on the East Coast about an ICE raid on a business, okay? Here's the quote. Approximately 15 heavily armed ICE officers identified as DHS, HSI, and ICE entered the supermarket without showing any warrants, judicial or otherwise. They walked directly into a designated staff-only area, screaming at everyone as per their MO, ordered employees to line up against the wall, and demanded identification. 3 of the men who complied were subsequently arrested. Okay, now I'm sharing that description not to scare you, but just to give you a sense of what to expect, which is that ICE will push the boundaries, right? It may even break the law. We've seen how this government right now basically has a contempt for both the law and immigrants, right? And then you combine those two together and you have a very bad situation. So even if you're following all the guidance that we have here today and you've followed all the steps, there's still a chance that ICE will not care and will come in and make some unlawful arrests. And here is where documentation becomes so important, okay? Now, Malou and I are lawyers, and we know that when we have someone who is unlawfully arrested, we would, of course, want to challenge that, challenge the way ICE arrested that person. It is difficult for us to do that when we are only relying on what our client tells us, because the judge will just think, well, that's just what he says. However, if we have video recording or contemporaneous notes from somebody else, and by contemporaneous notes, I mean either notes that you take while it is happening or immediately or soon right after it happens, those can have high evidentiary value. And they can ultimately help us, not only the client who maybe was unlawfully arrested, but it can really help to deter ICE from acting unlawfully in the future. So, I should have moved it to the next one. Oh, wait, no. That was documenting. So, I've written some of the points that you should think about when documenting ICE encounters, but it's basically sort of the, who, what, where, and when questions that you're going to do. I do want to point out, though, that if you are going to record an ICE interaction, you have to be smart about it. And frankly, you just have to use your judgment, right? You don't want to have any actions that ICE could interpret as being threatening. For example, maybe they think that you are reaching for a gun. So if you've ultimately made the decision that you do want to record this situation, what is happening in front of you, I do recommend that you say aloud, audibly, I am reaching for my phone, I am going to record this interaction and stand in a safe spot, right? If you don't feel like you can do it in a safe way, and when I'm talking about safety here, I'm not talking about your own safety, but also the safety of the person who's undergoing that ICE arrest, right? You don't want to escalate that matter because maybe it's already a little bit crazy. So you have to exercise your judgment in these situations, and maybe sometimes the best course of action is for you just to sort of take notes as it's happening, to record what's ICE saying, what are they doing, what's this person saying, what are other people saying, and then that can maybe be used later to help that individual. I don't think I really need to talk about this. I've just added sort of an action item checklist here. about some of the materials and workspaces that you can do after this presentation. And I think, really, I'll just stop there. Because really, the most important thing here, though, in my mind, is that you continue your services, right? Because like we said before, that what's happening is just this atmosphere of fear, intimidation. People are being sort of pushed into the shadows, and they will remain there unless they see people standing up for them. And we all of us here are in a position to be those people to stand up, to sort of bring them forward and say, no, we are going to continue our services in the face of this, and we're going to do it in a smart way. Okay, so thanks, everyone.
Thank you, Henry. So I know many of you maybe need to leave, which is okay. Please use those doors on my left or there, but we will go into Q&A session. So if you're able to stay for that, please do. We have an important question clarifying a right to an attorney. Malou mentioned that there is no right to attorney in immigration court, but then during multiple Know Your Rights sessions, people are recommended to say, I want to talk to an attorney. Can you reconcile those two things?
Yes. You do have a right to an attorney, but not one paid for by the government. So although you don't have to answer the questions and you can rely on an attorney, for immigrants, in immigration court, I should say, even though you're allowed to bring an attorney with you, the government will not provide a free one at no cost. If I get accused of a crime here in Washington and I don't have enough money for an attorney, Washington will pay for a public defender for me. But in immigration court, that is not the case. And so even though you should not speak to an attorney, hopefully you will be able to find ways to access an attorney or free legal services from places like NWIRP, our organization, or Collectiva, or some other pro bonos that might be able to, if you can't afford an attorney.
Thank you. There are a number of questions about validity of a warrant. One, can it be issued by a local court, or does it have to be a federal court? And second, does it authorize a search and seizure by a place mentioned in the warrant or by a person? So let's say if there is only a name of the person, can they go and look for that person anywhere?
Okay. Yeah, so for the first question, yes, it is possible for a state court. I would find it highly improbable because of some of the protections that we have in our state with Keep Washington Working Act. But so the first part is yes. The second part is hard to answer, but it depends on the scope of the arrest of what's in the warrant. You just have to read it yourself to determine the scope. It could say a person's name. It could just say a location. It could even talk about specific items, maybe that they want to seize your computers, for example. So it just depends on what the actual warrant itself says.
Thank you. The next category of questions, and there were many of them, is about the role of bystanders or other people observing ICE arrests. So what can be done? Can police, for example, stop ICE from coming into a public event? Second, can you announce ICE presence over intercom to the entire building? Third, can you tell people who you suspect to be undocumented to hide in private rooms?
Okay. The last one, I'll start because I heard it last. Can you tell people to hide in certain rooms? You can, but you might get in a lot of trouble. Okay, there are certain provisions where you don't want to be accused of harboring or interfering or aiding and abetting. And doing that, actively trying to hide or conceal someone, I could not recommend as an attorney because I think you would face all kinds of liabilities. Announcing ICE is here over the intercom. So I think that there are ways that you can think about this and doing it in a smart manner. I think that it is okay to announce factual things. And I think it's, just like I said, I think it's okay to announce inform people of their rights without necessarily directing them to do anything in particular. Announcing that ICE is there, I should have started by saying there are no bright rule lines. Right? There's no certainty, or like I can tell you with certainty that this will be okay or this will not be okay. There's just sort of a level of risk that you would be bearing. So a court might think, oh, just announcing ICE, you're not really directing anybody to do anything, so that might be okay. A different court, a different judge might think the exact opposite. You are obviously insinuating that you should run when you announce that ICE is there. So I would think that you would try to find a maybe middle ground, a better way, which is announcing that everybody has a right to remain silent, and that when you are encountering law enforcement or ICE, you have the right to an attorney, you have the right to remain silent, and you don't have to answer questions. And I would make it broad and not status-based. It would be status neutral because we're telling this to all of our clients.
Can you call for police to come and stop ICE on the street?
I mean, you can call, but I'm not sure, practically speaking, that police would have any, whether they would interfere with what ICE is doing at that moment.
Okay, and then the next category of questions, and again, there were many of them, were about private versus public places, and one specifically is something we've seen in the videos over the last couple of months. Is a private car in a public street and breaking windows without a warrant.
Yeah, so there's different rules when you're in a car, unfortunately, because cars are, even though you think of like, well, I'm inside my car and it's my car, you're actually out on a private street. And for general safety reasons, when you're pulled over, of course, you should ask whether for them to identify themselves. But if they ask for your identification in those instances, then yes, you are obliged to give them, for example, your driver's license. My suggestion is that is the only thing that you give them, that you give them only your driver's license. Now, we've seen those disturbing videos where they smash open the window. And I don't know the exact circumstances there, but it could have been legal, unfortunately, right? They could have had a warrant and already identified this person and recognized that this person is, in fact, the person they're trying to arrest. And generally speaking, ICE, like law enforcement, can ask people to leave the car as well for their own sort of safety concerns, because you're in a car. But you still have rights, right? The right to remain silent. You can give them your identification, you can give them your driver's license, but then not give consent to anything else, including searching your car or talking to other members, or answering questions.
And there were questions about private space of, is it a private space, your yard or your driveway? Do you have to have a fence around your house in order for somebody to know for sure it's private?
Yeah. I'm going to ask Malou to correct me if I'm wrong, because this sort of like makes me have to think about my law school days, which was a long, long time ago. But there is this idea of curtilage. You have a private space like your home, but you also have this sort of like these porch areas that you do, remember we talked about access in public and private spaces. So you do have some places that are these quasi areas like your porch, like your driveway, which we call curtilage. You still do have a right to privacy there, right? But usually what happens is ICE is allowed to go to your porch, right? Just like you will let anybody else to your porch. But once you tell them to leave, just like somebody who's trying to sell you, a vacuum cleaner, they should leave at that point. But practically speaking, if you are under surveillance, I do think ICE would comply with that, but they would probably stay nearby to watch to see if you're there.
Okay, and for somebody who's renting a room or a dorm space, who can give a permission to enter? Is it the owner or the person who's renting it?
So I don't know the answer to that question. There are certain laws where landlords are allowed to enter in. I thought it was limited to when they had to fix things or emergencies, but I'm not in a position to answer that because that sort of covers certain areas of housing. Malou, maybe.
And hopefully the landlord is attending trainings like these, but I think it does become the owner of the home's permission and consent, or judicial warrant. However, the room is the person's private space, right? So I think beyond the room, they should not, or beyond the house, they should not enter the room.
And how do you safeguard against ICE being in plain clothes coming to your programs under disguise of there to be receiving services that you normally provide? How do you prevent them from using that tactic to enter?
Yeah, I mean, the truth is, ultimately, you can't prevent ICE from doing what it wants to do, right? But what you can do is when you recognize that they're doing something unlawful, you can try to invoke your rights against these unlawful actions. And then you can document it in hopes that not only will they be in trouble for it, but or you will be released from whatever confinement they've put you in, but then you're deterring their future actions from doing something like that. There is litigation that happened, right, for warrantless arrests, for example, in Chicago. And it did result in certain policies that it didn't occur nationwide against ICE. And this was as a result of people documenting it and talking about these really terrible tactics ICE was doing when they were arresting people. So there were some bystander questions, and I do think it would be great if people do document and do pay attention and do try to get the word out on these seemingly unlawful tactics that ICE is using against immigrants.
Okay, I think we will stop with the questions for now. For the purposes of us recording this event, I'm still gonna go and do a little presentation about the Seattle and Washington State being a welcoming city. In the meanwhile, Malou and Henry, you have access to questions if you want to continue looking through them. If you find some particularly interesting or worth answering, we'll come to those as well. So I'm Oksana Bilobran with Seattle OIRA, and here just wanted to talk a little bit about Seattle and Washington State policies, because we hear a lot about Seattle and Washington State being welcoming, or as it's often mentioned, sanctuary jurisdictions. So, so you would know exactly what it means and what it doesn't mean. We get a lot of questions about how is it even possible for ICE to operate in Seattle? Aren't you a sanctuary jurisdiction? Or like even today, we got a question about Seattle police. Does Seattle Police Department play a role in enforcing immigration law? Or on the other side, can it prevent ICE from enforcing immigration law? So we are lucky, I would say, to live in a both welcoming and sanctuary city and a state. So both the state and the city have policies to limit cooperation with ICE, and it's not like that across the country. So for example, in New York, the state of New York doesn't have welcoming or sanctuary policies, but the city does, and that creates confusion where people have to be mindful when they move across jurisdictions from one county to another. So we live in a state that has a Keep Washington Working Act, and I'll talk about it a little bit more. But specifically to Seattle, we have policies on the books from a long time ago, from early 2000s, that prevent the city employees from asking about immigration status. Also, our policies say that the city services are accessible regardless of immigration status, so anybody can access those services. And the Seattle Police Department actually does not enforce immigration law and is prohibited from entering into contracts with ICE in order to enforce immigration law. We, as I mentioned, in Washington State have a Washington Keep Working Act, which was passed in 2019 that specifically prohibits law enforcement from inquiring about immigration status. Also bars sharing personal information with federal immigration authorities and forbids detaining people solely based on their immigration status, and prevents contracts from being entered for civil immigration enforcement. I highly encourage you, if you are a service provider, to check out the website of the Washington State Attorney General, because they have developed these very useful policies, model policies for law enforcement agencies, also for public schools and for shelters and other providers of services to the community. So today when Henry was talking about you as the organization that serves vulnerable immigrants and refugees having to have a plan on what to do when ICE comes in or how to protect your residents, for example, I would suggest the first place to start would be looking at these model policies. And for many of you, it would be as easy as literally copy-pasting it to your procedures, standard operating procedures of your organizations. Because I was checking out questions, there were a number of questions about the role of Seattle Police Department in enforcing immigration law. So I'll just answer it. There is no role that we play. We are not doing the federal government's job of enforcing immigration law, but we are also in any way preventing them from doing it. There is a separation of power. Federal government does what federal government does, and Seattle Police Department is here to protect safety and well-being of all of Seattle residents, but is not here to protect us from ICE or somehow do ICE's job for them. That's it. I know we had to cut the presentations a little bit shorter, but we are 2 hours now. I don't know if Henry or Malou, you identified any other interesting questions. If not, we can just end it on this. We really appreciate your presence here. We hope you connect with us. We have a number of trainings still coming up, and one of them is about rights of employers and business owners. That event is taking place next week. So if you know anybody who would be interested in that, there are flyers here on the table and more resources as well. Thank you again. Thank you for coming.